This drone video was shown on Fox News a couple days after the incident. It apparently was on the internet briefly and then taken down. The defendant's first attorney, Mr. Pierce, appeared on the Tucker Carlson show and discussed the video and seemingly brought the video. We've been told since then by the person who took the footage that they've sold the video to Fox News. Now, we've had a poor quality of this video the entire time. It's actually in Exhibit 41, which the defense submitted. On Friday, the individual who took the footage, who had been unable to find, came and airdropped the footage to Detective Howard. Airdropping is a way that it just goes from phone to phone. It doesn't go through text messages or email. It has to be iPhone to iPhone. So in the middle of Mr. Lukowski's testimony, I asked Mr. Howard to go, and our investigator, to go speak with this individual and see what he had. I suspected it was this video from the Tucker Carlson show. It was. Detective Howard got an airdropped copy. He brought it into court. As soon as the next break happened, which I believe was just minutes after he arrived, as soon as the next break occurred, which I believe was just minutes after Detective Howard arrived, I took all three defense attorneys in the back to discuss a couple of issues which are not relevant, and I also indicated that we now had a much better quality drone video. Detective Howard asked them how they would like to receive it. Ms. Wisco asked that it be emailed to her. He emailed her the file. Now, somewhere along the lines, whether it was, it appears the issue is, I believe Ms. Wisco could not have an airdrop because she has an Android phone. Going from an iPhone to an Android, it appears somehow compressed the file.
Was she made aware of that? Because I have an Android phone too.
We did not know that this would occur. If I knew how to compress files and knew all this technology things, I'd have a much better job. So this file was given to us. We gave what we fully believed was the full file to Ms. Wisco. It was admitted to evidence. It was the authenticity was stipulated to. It came in without objection. We've heard many times this trial how there was no objection. It was an exhibit for 4 days and played and shown to the jury and on the screen for 4 days. And then on Friday is when I think we all discovered that something had happened to Ms. Wisco's file. She played it on the big screen. It clearly looked different than the copy we all had. I believe we offered to airdrop it to the other attorneys, and I think it was declined because they didn't know how to use airdrop. And then we got her the full copy. We cannot be held responsible for the software on Ms. Wisco's phone. We didn't compress anything. We didn't change anything. That would have been something that happened in the transfer that we had no knowledge of. We of course did not mean to give them a different copy, and until Friday when Ms. Wisco played it and it looked different than what we've been looking at, we had no idea it was any different. And then when requested, I gave her, so what I did is I took an email from Detective Howard. He emailed me the file. It was not compressed. I don't know, probably because it's Apple to Apple, or I was using Gmail at the time. It was the full, as far as we know, the only copy of the video we were ever given, the only copy that's ever been had, and then I put it on a thumb drive to give the State Crime Lab. So I cannot explain why Ms. Wisco's file had been compressed. That is not something that we can be held accountable for. We didn't know it. We don't, and if Ms. Wisco knew it, it wasn't brought up until Friday. Now, there was some dispute Friday about there being different copies. There was no different copy. The software on Ms. Wisco's phone, or whatever software she used to view it, compressed the file. The only compressed file is the one Ms. Wisco has. All the ones that we have seen, and we did not alter the file. None of us know how to alter the file. None of us know how to compress the file. we wouldn't have had time to do so. You can probably go back on the footage and see when Mr. Howard, Detective Howard brings it in, and while Mr. Lukowski is being questioned, we're looking at it to see if it's the drone footage that apparently the defendant's first attorney had or was aware of. And I understand he's different attorneys now, but this is still the defendant's attorney at the time knew of this 3 days after the incident and was talking about it on national television. So to somehow now accuse us of compressing a file and somehow being able to do this technical wizardry to somehow sabotage the defense is preposterous. The defense saw this video and thought highly enough of it that they went and bought a large television that is now being used in court because they wanted to show it. And now all of a sudden to come back and say, well, we had a bad copy, they could have checked, they could have asked for a thumb drive, they could have asked for whatever. As far as we knew until we had this hearing on Friday, everyone had the exact same copy. And that Ms. Wisco's phone compressed it is not our problem. It's not, we're not responsible for that.
She can go to her phone.
If I may.
Well, no, one at a time. One at a time. Well, why don't you start, Ms. Wisco?
Can you talk into a microphone? Yes. On November 5th, 2021, I received at 10:33 a.m. an email from Detective Martin Howard with one video file attached. It was a 4 millibyte video that was titled IMG_0159.MOV. I have never looked at that video on my cell phone. As soon as I received that video via email, I downloaded it to this laptop, which is the evidentiary laptop we've been using through the duration of this trial.
What manufacturer is that?
This is a Lenovo.
Okay, go ahead.
And I relabeled it after it had been brought into evidence by the state as Exhibit 73 because it was Exhibit 73 for ease for bringing it up, showing it to the jury. After we found out in Friday that there was this discrepancy after the videos being shown, and for the record, we did not buy that TV because of this drone video. We actually brought it in for John Black's slowed down testimony. That was the reason we brought this TV in. However, when we were in court, I played the Exhibit 73 on my computer because the state's computer wasn't here. ADA Krause was the one who brought up the fact this isn't the good quality video. We didn't realize until playing them side by side, mine and then the state's, that there was any difference in quality. That was Friday. After Friday happened, I emailed both Binger and ADA Krause, and I asked for an exact forensic copy of what they had given to the state crime lab. ADA Krause responded back to me, forwarded me the email he's talking about to Detective Howard, and that also contained one file named as IMG_0159.MOV that was a 4 megabyte file. Simultaneously, ADA Binger had been in contact with me, told me I could come pick up the file from a flash drive. I drove here, I had him take me inside, and I confirmed that this file that he said was directly provided to the state crime lab was an 11 megabyte file, not 4. So the information contained in the flash drive was over double the size, almost 3 times the size as to what was emailed to me. When ADA Krause followed up to me with that email, forwarding me his email from Detective Howard, it was the same 4 millibyte file that I had gotten previously.
So clearly Attorney Wisco's email is compressing these files. That's not our responsibility. Oh, I didn't write Outlook software.
You know what?
I forwarded
Well, wait a minute. I don't know if she had finished.
Every other piece of evidence from the state crime lab in this situation has been provided to us via Dropbox. Dropbox provides an exact forensic copy of what they have. The file title name in this situation should have been exactly the same as the one provided to the state if it was the exact same copy. The file name was nowhere near similar. The one that was provided to the state crime lab that Attorney Binger gave me a copy of on Saturday had a very long, convoluted title that involves lots of letters and numbers that are the type that are usually associated with files taken from a drone, because they indicate a lot of different information, like the location of the drone and the time. The file I received originally on Friday the 5th was not labeled that same and was not the same file amount. There's no way that what ADA Krause is saying is true, because the file name would not have changed if my computer was compressing anything. It was a different file that we were provided from what was provided to the state, at least for what Attorney Binger gave me on Saturday. They're completely different.
I think we're confusing the issue here. The work product of the State Crime Lab is sent via Dropbox. That's how they've submitted all the videos that they worked on and the photos they worked on. The email from my personal Gmail account is the file that went to the State Crime Lab. I was told to bring it to the State Crime Lab. I was already home on Saturday. I did not have access to anything but my computer. I had Detective Howard email it to me, and I put it on a thumb drive at home, and I took it to the crime lab. I don't know if Mr. Binger somehow retitled it, but the image I gave the crime lab is on my phone as the title that she indicated. That was the one that went to the crime lab, and I will testify as an officer of the court. I take offense that what I'm saying is untrue. Clearly,
well, obviously we're going to have to take this testimony under oath, and we're going to have to get somebody to explain all this, who has some competence, which...
If you look at the report from the State Crime Lab, they indicate the originating file that they received was the one with the expanded title that we did not receive until Saturday. If it had been the same file as ADA Krause says it is, why wasn't that labeled on their receipt as being IMG 059 or 159?
Mr.
If that
Krause?
is the exact same thing, then that does not add up.
Mr. Krause?
Why did he include in his report a different title?
I'm looking at the email. It is image0159.mov. When it's downloaded to computer, perhaps it has a different title. On my phone and on my Gmail, that is the image. I'm watching the video right now. This is the precise one that was given to the State Crime Lab. I had no other access. At this point, the first time this was ever put on any kind of hard drive is when I did it Saturday at my home. And I'll do a little experiment here. I'll save it to my computer and see if the title changes. But
we're going to do this. Pardon me?
I accidentally saved it 3 times because I was trying to re-download it multiple times, and it all saved it as IMG 0159.
Okay. Well, you know what? We can't resolve this now, because this is going to require expert testimony from people, and we're going to have to take testimony under oath as what the facts are, and so that I'll reiterate my comment, which started this discussion, which was that given the cloudy picture about this particular exhibit, this is a high-risk strategy for the state. I was queasy about this from the beginning, and I'm only queasier about it now.
Judge, what we propose is to show the jury the exhibits. I'm really not concerned about the image. As I've said multiple times, I believe much too much has been made of this image. Mr. Binger didn't even mention it in his closing. We didn't show it in either our closing or rebuttal. The other evidence was admitted without objection with a stipulation to authenticity, and I believe it should be played. It's already been played for the jury, and they should be brought down, and we can put all the other exhibits on a thumb drive outside of 160, what is it? Outside of exhibit 155, which is the image that the court has received over objection. But the other exhibits were not objected to. And again, the defense, although a prior attorney, had access to this video 3 days after the incident. So to now claim that they're somehow prejudiced is preposterous. I understand it's previous counsel, but it is still the defendant's attorney. He was charged with this crime, and if Attorney Pierce did not turn something over that he had and that he seemingly brought to the Tucker Carlson show, that also is not our responsibility.
Your Honor, can I briefly respond to that?
Yes, sir. Yes, sir.
Mr. Pierce was my client's attorney. As Mr. Kraus said, Tucker Carlson purchased that video. That video is very different from the video that was delivered here in quality, color, there. We stipulated to the video based upon what they gave us. We didn't see it as anything different. We were given...
I want to stop you now.
Okay.
Because why do you say that the one that Mr. Carlson bought, Tucker Carlson bought, is different from...
Black and white.
That was, okay. Go ahead.
And we stipulated to that video when we looked at our copy because it didn't add anything except color. We didn't have the quality. And that's where this whole problem starts. And we weren't aware of the quality until after the evidence had closed on Friday, when we were here and it was plugged in as Ms. Wisco was saying. That's when we found out there was a problem, what had been given to us versus what they had. That's when the whole problem comes up. So that's as to that video. The other one, and I'll just say it because it's going to be an issue, FBI aerial with all POI'd marked. That, when we're going over this list, it's come to my attention. I played that for the jury. It never got marked or moved in, even though it's been played.
Are you kidding me?
I am not kidding you,
Can we
Judge.
put it in evidence now?
That's what I think would be the proper way to do it.
If the defense agrees that all the drone videos go back, we will agree that that should be
Can I
marked
run a
in
compromise?
evidence.
This isn't, let's make a deal here.
Well, they did not mark the evidence. They did not move it.
But it was played to the jury.
Yes, and not marked or moved.
I thought it was part of the hard drive because everything was going in.
And I thought we gave them a full and complete copy of the video. So.
Well, I'm going to reopen the evidence and admit what they saw. Give it the next sequential number.
Well,
how can I not give it to them? You tell me.
I mean, then I would ask that evidence that's been admitted also go to the jury, that has been legally admitted in front of the jury, and follow the proper procedure.
Let's take one thing at a time.
Your Honor, just for the record as well, there was an additional difference that we found in the metadata between the two videos, is that if you look at the metadata from the file that we received from the state, is their create date is 11/5/2021 at 15/10/31. If you look at our video that we were provided, the metadata, the create time is 21 minutes and 19 seconds later.
Judge, we're looking at the Tucker Carlson interview with Attorney Pierce. It is not black and white, it is color, and it actually does seem to be high definition, like this video. We're watching, it's online, you can watch it.
The one I have is black and white.
Mr. Rittenhouse's attorney has seen the real version.
What about that? If his prior attorney, he's got it.
I don't know. They said that Tucker Carlson bought it. And that's what goes to this whole thing, this urban air. We sent out an investigator to interview the owner of Urban Air to try and get this video. And I can get the report. I don't have it with me. And the individual lives out in the Lake Geneva area. And he lied to our investigators and said, we are mistaken that the drone permit wasn't for this video. And now it's come from his company. He shut down his company 17 days after this video was released. We've tried to get this video, and then it shows up on the Friday after the trial has started. And it's dropped off by his employee, not the person who we interviewed who owned the company.
I don't know who was interviewed. I believe that is the owner Mr. Beeman?
Oh.
Okay.
I'm shaking my head no. I answered no to Mr. Carlson's question. I apologize.
Well, this is number 5, and they say, please prepare. And then it lists these things, and then it says, we will request when ready, and they haven't followed up. So I'm playing short. Maybe the ball won't come to me.
So, well, if we're moving on, at least for the moment,
Let's move back.
let's go to number 4.
Yeah.
So it seems that the request, it says view video, but I believe it's actually 3 videos.
I did not hear you, sir.
It asks for a video, but I believe they're actually asking for 3 videos, and I think we agree on this, that it asks view video starting with Mr. Grosskreuz's interview with Mr. Rittenhouse. That is Exhibit 3. It's also duplicated as Exhibit 57. That is the live stream that Mr. Grosskreutz took that night. That does not actually depict the second incident. It does, you can hear the shots, but then it asks to 10 seconds after Mr. Grosskreutz shooting. I believe that's what's referred to as the BG on the scene video, which is number 5. And then it indicates in regular and slow motion. The only slow motion of that incident is the BG on the scene video, and that was the one that Dr. Black created and played. That was moved and admitted. It does not formally have a number because it's on a drive. We do not object to it being given a number and sent back, or well, played however the court deems appropriate. So we would ask that. So I believe there's 3 exhibits they're requesting. The state does not object to them having access. However, it is deemed appropriate to those exhibits.
All right. So, and that's by agreement. And then the question is where and what restrictions will be put on their use of those videos.
The state's position is that they should be given the exhibits or told what numbers they are. The courtroom should be cleared. They should watch them on the monitors they've been watching the whole case on. And that can be set up, and then everyone can leave, and they can discuss it. Now, it says...
all by themselves, or...
by themselves.
Okay.
Just as they
I
are in the
assume
jury room.
that somebody has got the technical ability to trigger playing of the videos.
That's a fairly simple process. They can be given a computer with you just plug it into the side, and then they can just press the thing. If there's...
Computer, it doesn't have other matter on it?
We have, I believe our computer, if it doesn't have anything else in this case, it may have like Microsoft Word or something on it, but there's no other evidence of this case on it. It's not my computer. It would be we have some standalone laptops to do this type of thing.
What's the defense position?
We were talking about it, and the question that I have, and I don't have an answer because it wasn't in any of these cases, is there any right, if we're doing it in court, is there any right for Mr. Rittenhouse to be present?
More than if they had paper exhibits and they were discussing them. And certainly the defendant can't be in the room while they're talking about them.
Well, I agree with that.
Why is the video different?
Well, if you clear the room and say this is now the jury deliberation room, which is what they've asked.
No. I want to go back a step.
Okay.
Supposing I said, well, let's just get a computer that has nothing else on it, or that is everybody feels it's sufficiently sanitary, and let's put these exhibits on a flash drive or download them onto the computer or whatever, and then send that upstairs. Let them do it just like they would if they were paper exhibits, and they can play it and discuss it as much as they want. Now, I'm talking right now only about question number 4, because there's other issues with respect to question number 5, and fortunately they're not here yet because they haven't requested it. But this would be a departure from the Anderson case for sure. That would not be incompatible with what I did in the Flint case. Flint. Who's okay with that?
I'm sorry?
Who's okay with that?
We are okay with that.
Based on what you said, so we're not waiving anything on 5.
You're not waiving anything on 5.
Then that's okay for 4.
Okay, now we just need to get a clean computer. And you say you have some available, Mr. Krause?
Yeah, this is
One of those?
I have to look at it, but it can be clean quickly.
We'll look at it. Well, I'm going to go and do something else. I'm not going to go. I'm going to stay. I'm going to stay and do something else. And I'll let you fellas try to work this up. And
At this point, Your Honor, they have not requested what we're fighting about.
they have not requested.
At this point, they have not requested what we're fighting about.
You are correct.
Okay.
saved directly to the desktop of this computer. They need to be played through the VLC media player app. That is the only thing that the jury needs to know about it. I already have it brought up on the screen. VLC.
It's all Greek to me.
Yes. The application is already up on the computer. All they need to do is go through the application, click open file, and then they can view the videos.
I wonder if you could just write down a little piece of plain notepad, so they have that. They probably would know, but there might be someone like me up there who wouldn't.
It's the only, I believe that Windows Media Player is the default. However, if you try and play them through that, nothing comes up. Sure, we can reset the default.
Okay, so we're all on board with that. Mr. Rittenhouse, you know what's happening here?
Yes, Your Honor.
Any question about it at all?
No, Your Honor.
Any problem with this?
No, Your Honor.
Okay.
Judge, while Attorney Wisco is preparing the computer, during this little break, we've done some more looking, and in terms of the drone video, I don't want to re-argue it, but I just want to state what happened. When Detective Howard obtained the video, he airdropped it to my phone, which is a lossless type procedure, or at least it didn't change anything. At some point, I emailed it to myself, which did not change anything. It has the file name, the long file name. I did ask Detective Howard to email it to me as well. Then it had the IMG file name that Attorney Wisco received. So somehow in this Detective Howard transmitting it to everyone, if it was emailed, it was compressed. If he airdropped it, it was complete. And that was not known by anyone until a few days ago on Friday.
Well, it passed. This may pass. They haven't asked for it yet. They wanted us to be ready, and of course we're not. But let's take a step at a time. And I just heard their bell ring, so perhaps they have something more of interest to us.
So, Judge, we've been talking. If they do come back with question number 5 or whatever it is, whatever. You have talked about in great detail and length, and it's completely appropriate, the transparency of wanting this to be a fair trial and everything else. And I'm finding that difficult in that one of the linchpins of the state's case was information. Go ahead.
I'm just going to interrupt you long enough to have the material that we've agreed to go up. So if that's ready, Ms. Wisco, we'll have the bailiff take it up. They're ready for the video. I don't know what that means. But let's send up what number 4, and then we'll hear the rest of what you have to say about number 5. So is that ready to go up?
Yes, I'm having problems with setting it as the default because of the way that I sanitized the computer just now. So if we can go up with the note saying must play.
Send the note up. Have the DA look at it and make sure it's okay with them.
If you can make sure they plug the power cord in because the battery is low. It says must play all videos through VLC media player.
All right.
Okay. Question 4, it's coming up. Yeah, go ahead.
If you can please keep it open though, so then they don't have to log in.
Yeah.
Thank you.
Excuse me. It's no longer allergies. It's a cold. But go ahead. Yeah, there's no restriction on their use.
So, Your Honor, we were talking during the break, and the reality of it is one of the main portions of the video, the thing that you watched, however many times you watched it, right, on a video that we had the video, not the clarity and not the quality. I think that's been conceded that we didn't have that. We would have done this case in a little bit different manner if that was the situation, where we didn't have specific, and I want to say we didn't have the evidence because I don't think that's a fair way to say it, but we didn't have the quality of evidence that the state had until the case had been closed. On Friday, the parties had rested, and we were going to open our closings on Monday. We've talked to Mr. Rittenhouse, and I'm going to be asking the court for a mistrial based upon the fact that if we're really trying to get to the heart of it, we've watched the video, I can tell you what we think, but it doesn't matter what we think because we don't get to present that to the jury anymore. And I think if we're going to try to do this in a way that is free from anybody hiding anything, anybody not having the same evidence as everybody else has, where it is clearly a level, fair playing field, we have to ask for this, and I'm asking for it. We understand that it's going to be without prejudice. We understand that the state can redo this case if the court grants it. We understand they will do it again. But then I think we will all have the same information, the same quality of videos, and I think that is required in a case like this where he's looking at a life sentence, potentially without parole if he's convicted. And to not get that until the evidence has already been closed, that doesn't strike me as fair. So for those reasons, I'm making that request.
All right. I'm not going to invite the state to respond yet because the jury has not requested to see number 5, and it'll still have to be addressed because the jury saw it here in the courtroom. But
I'm sorry, Judge, but if I understand Attorney Trofsky's request, this is a motion regardless of what the jury is requesting.
I think we're making that request because it's been shown, it's been pointed out, and in fact we didn't have access. And I'm at this point, I don't think me pointing fingers and doing that is going to be the end all be all. I think what it is I can tell you, and I think the state can tell you, we got a compressed version which was not of the quality that they had. We learned that Friday after the evidence had been closed. We learned that when we tried to play the video for Your Honor, and the state asked that their AV person be brought over to play their video, which was a higher quality. If this is a disorderly conduct or something, I get it. But we're talking about a potential life sentence here. So I'm making that request.
And again, I'm going to say that it has to be addressed if there's a guilty verdict on any degree. That count. Well, even perhaps on the others too. I don't know. It'll all depend on a number of factors. Then the motion will have to be addressed. But it doesn't seem to have the urgency right now until the jury, if and when the jury asks for number 5. That doesn't change the fact that they're making the motion, or that it could affect the case as a whole. But I'm not going to invite your response now until I know whether the jury wants number 5. Does that make sense? If it doesn't make sense, tell me.
He
was told that they were ready for everything. So, that you have the state's response.
Response invited.
Yeah.
The defendant's first attorney, after he was charged with this case, appeared on an interview, appeared alongside the high-definition version of this footage. I understand he's gone through other attorneys since then, but the defendant himself would have been aware of it. His legal team would have been aware of it. Obviously, both sides have attempted to get it, and we were not able to do so.
What do you mean you couldn't? If you know Tucker Carlson's got it, you could have subpoenaed it, no?
We didn't know that until, I think, today.
No, we knew it.
What did you think it was?
We knew it was aired on his show. We didn't know that Fox News apparently purchased and has possession of it.
Okay. Did you inquire?
We tried to find Brennan.
We tried to find the person who took the footage and who ended up being the person who came to our office with it.
I interrupted you. Go ahead.
So this is not a video that was in possession of the state in any way, shape, or form. It was out there in the, I guess, on the internet and in the world in that regard. And I think we're focusing on too heavily on, I guess, a technological glitch, and less on and we should be focusing that this exhibit was played. The jury is asking to see exhibits that they have seen and that the defense saw when they were played in court. What's on my phone or my laptop or the defense's phone or laptop is of no matter. What matters is the exhibit. And that exhibit was played. It was not objected to. The authenticity was stipulated to. And the defense, I understand they didn't realize it till Friday, watched this exhibit. They watched it on a television set a few feet from them. They could have watched it on the monitors here. That is what matters. That is what the jury sees. That is what they have seen. That they want to see it again is not prejudicial. It's not prejudicial in any way that the defense had a compressed version now. Obviously, they had seen or had a full version at some point, possibly prior to Attorney Richards becoming the primary attorney. But that is not the fault of the state. And the fact that that some technology compressed this file without anyone's knowledge until Friday is not the responsibility of the state. And Defense Exhibit 41 has this video in it. So to pretend that somehow they're surprised or they didn't know about this video, they've tried to find it just as we did. We found it and there was a technological glitch. Or not a glitch, but I guess it worked in a way that is designed that we were not aware of. And Exhibit 41 not only has the drone video in it, which is the defense exhibit, it also has a circle around someone pointing the gun. As I said in my rebuttal, this did not seem to be a great issue until the defendant testified otherwise on the stand. And now all of a sudden, the defense is calling into question technology and not wanting videos in, and it's all to protect their client. And I understand that is their job. I'm not criticizing them for this, but their client lied about this on the stand is the state's position. There seems to be evidence to support the position that he lied on the stand about raising the gun. He was confronted with the exhibit. He denied it. The jury wants to see these exhibits, and I understand there may not be a final ruling on a mistrial until we see what happens or if it's even necessary. And they had their own expert that could have looked at this video, and I'm sure did look at this video, and there were questions at the very beginning of the trial about, or perhaps even before the trial, about the resolution of the FBI plane video, a whole different video. Their expert looked at that. I'm sure their expert looked at this. Their expert must have missed it, that it had been compressed somehow. This is not a resource we had available to us. And I believe the motion for mistrial is inappropriate. I don't believe it should be granted. And coming back to number 5, they're asking to see exhibits that have already been played, and with the exception of the image, exception of 155, were not objected to. And the court has said many times when the state has tried to raise these technological issues, well, there wasn't an objection. And we're asking for the same treatment now that these were not objected to. The defense has had access to the exhibits. They've had access to the drive, that they didn't realize it and we didn't realize it till Friday. That there was some sort of difference is perhaps unfortunate, but they're also responsible for I'll withdraw that. Anything else? So the state believes that we believe all exhibits should go back. Again, I understand the court has concerns over the still image. I understand that might be in a little bit of a different category, but in terms of question number 5, and I'll just, while I have the floor, I'll just go through what they are. The FBI aerial with all person of interest marked, that would appear to be the defense exhibit that they neglected to mark and has now been accepted. The state also has one, which is Exhibit 25, which has Mr. Rittenhouse and Mr. Rosenbaum marked, but not the Zeminskis. So I assume they mean the defense exhibit, but we could send both back or have them come down and view it, however we do that. The drone video is 73. That's the full unedited exhibit that's been in evidence now for over a week. The zoomed in still image, we all have talked about that and beaten that horse to death, so I'm going to skip that for now. Then the full event video in regular and slow motion, that seems to be the drone video, as that is the only video of incident 1 that was played in slow motion, just as the only video of incident 2 in slow motion was Dr. Black's. So their expert video was submitted. Our expert video is, I believe this is actually 6 videos that they're asking for, which is the drone video. It's spliced out, so it shows the first third of the incident, the second third, and then up until the end of the shooting, and it's in regular and slow motion, and that's exhibits 581, 582, 583.
S82.
I'm sorry, S81, S82, S83, S84, S85, and S86. And we believe that the jury should have full access to them. They should have full access in this room. And that's our position. I do not believe a technical reality, shall we say, or an unknown technical incident should result in a mistrial.
How would we object?
Pardon me?
How would we object to something we didn't know existed until it was over?
I didn't find that point particularly persuasive because, but anyway.
It's impossible for us to do that. And if everybody in this room that's a lawyer has been a prosecutor. Your job is fairness and being a truth seeker. It's not debatable that it's not fair what happened. We can sit here all day and say it's been played. We didn't know there was another version. How is that reasonable?
Well, I persistently warned the state that, there's a day of reckoning with respect to these things. My feeling is I had my qualms, and I decided, well, I'll let the jury hear it. I think I made the comparison the other day of the breathalyzer, where the officer doesn't have to be familiar with how the breathalyzer does the analysis, but that's a device that has been sanctioned by the courts, and I just don't think we're at that place with this, and particularly if they've got evidence. I didn't see that in your motion about the manual.
We've learned it since I filed a motion.
Well, if they've got the manual, I don't know. It may be. I forewarned you. You've pressed with this, and that's fine. I've let it in, and my view on it now is where we are. We might as well follow through with it. And if they've got everything correct and it's reliable, then they won't have a problem. If it isn't, it's going to be ugly. All right.
I would just note that the defense, I'm assuming they were paying attention to the trial, would have known on Monday when Detective Antremian testified that that version was different.
We're going to talk about it because I've made the decision. I'm going to be played. You've suggested that it be played here in the courtroom under whose supervision? And
this becomes the deliberation room for that portion as they watch the video.
I'm going to be in the room with them.
The same people that are in the room with them now.
Well, why come down if they're just going to be looking at? I mean, Are you saying that they come down and hear it with all of us in here?
No, I'm saying everyone leaves.
Okay, well, why not just leave them up there?
Because the screen, watching it on the screen that,
I got you.
And that goes, the problem we're talking about on 5 early is the request 5.
Yeah.
We're talking about the problem.
The last word you said.
The problem we're talking about on request 5 is on the front end so far, and it goes to the same thing with that television, adding the pixels on the back end. So now they're looking at it on a computer upstairs, and I don't know why they're not looking at this on a computer. Meaning 5. I put my hand on request 5.
Well, and how many times? One time? Is that what you said?
I didn't know. I think just as they're, no, I think they should be free to look at it as much as they'd like.
That would be my bias, frankly.
We've laid out.
But we've got the law that you cited the Anderson case. I have ruled in the past, and I'll rule again. The Anderson case is not applicable to images of the event, only to like statements and that types of thing. So, but I'll hear you out.
Judge, that's the. I mean, I'm relying on a Supreme Court of this state's case. I understand that you're separating them, and I'm not here to. I'm just here to tell you that we object to it being played over and over. What I've learned from your case with the videotape or the cassette tape and Anderson, both of those cases talk about not there being an overemphasis on specific parts of evidence.
Possibly overemphasize a video of something, unless I suppose if it's not an accurate video, I suppose then you could. But then you're overemphasizing it when you see it the first time.
That has been the concern of the court in having them when I say them, having the jury have just unfettered access to it. In Anderson and in I think it's Franklin, that was the part of the concern in both cases.
And I will repeat, I think it's the fact that we have to censor what the jury uses to decide. When the founders of the country gave them the power, it has to be censored by the judge. That's really insulting. So I certainly I'm not going to say there aren't cases where a jury could overemphasize something, but for me to say, well, there's a video that is purportedly an accurate depiction of what happened, and you can only look at it so many times, I'm not going to do that. So they know the risk and they've assumed it, and so they can watch it. They'll do with it as they see fit.
So I understand they're ruling the videos. We do not object if the zoomed in image is not sent with them.
155.
155.
Well, I'm going to leave you gentlemen to confer, and as you did before, and came up with a workable.
How do you wish? Should we put it on a drive and send it to the jury, or are they coming down here?
Why don't you give them a drive, because then they've already got the clean computer to work with to put it on a drive.
You want to use this too?
And then they'll come down here, and presumably they know how to work it, or if they haven't told us they can't. They can come down here, and they can operate it from wherever they're comfortable, and we'll all clear out of here. And okay?
I will work on that.
Okay. You confer and come up with an agreement to which you object. A working agreement to which you object. Now let's do the case of the state against Emmett Zier. Work for them?
Yes.
Okay, good. Where's the DA? Oh, here they are. All right, what's going on is that the parties have agreed on a mode to present over the defendant's objection, the material requested in note number 5, I think, and that's ready to go, and it just needs to be, the right button needs to be pressed, and they can play what they want. And we're going to evacuate this room. Everybody, including everybody. Only the jurors will be allowed in here, and they will be instructed to knock if they want. The bailiff will be outside the door, and the media have to leave. And if you leave anything electronic, the bailiffs are going to search the room. If you leave anything electronic here, make sure to say goodbye, because you will never see it again. With the exception of Court TV's materials that are too hefty to move, but they must be shut off once I've instructed the jury. Any question? Okay, fair enough. Let's ask the jurors to come down.
We need a minute to make sure everything's clear.
Okay, and do you need Mr. Kraus here too?
No, but I would
Okay.
recommend that the deputies or the bailiffs walk around and make a visual inspection to make sure there's nothing left behind.
Sounds good. Officers, will you do that? Make sure there's nothing left behind. The jury room while they're doing their work here. Now, this is going to be very short. I'm just going to tell them what's going to happen, and then the minute we all leave, then everything's got to be shut down. Okay. The latest we can go to the 11 o'clock. Just so you know, I will tell them then.
Okay.
Okay, you want me to play some music? Yeah, autumn leaves and autumn leaves start to fall. Da, 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 da.
Are we waiting for them to clear?
Huh?
Are we waiting for the people in the back to clear?
They can stay because they're still making a recording, but or live. I don't know. But anyway, they're okay. But only until when we leave, they leave. All right, folks, you're here in respect to your request number 5, and what's going to happen is I think it's all queued up, and all you have to do is press the right button, and you can view the material as much as you like, and you can close in closer to the screen if you want. It'll be your call. You can discuss it, and you'll have complete freedom of privacy because we're all going to be out of here, and we've already done a check to make sure there aren't any kind of devices that would pick anything up. Then when you're done, there'll be a bailiff outside this door, and just knock and advise the bailiff that you're done, and then you can return to the jury room. Any questions?
Both screens.
I believe that's the one. It's going to be that one. Okay. Any question? Yeah, ma'am. The court TV? Yes, they are. I permitted them to stay in here while I did this explanation to you, and then we're going to leave and they're going to leave. There'll be nobody in here but you 12 jurors. Okay, no sitting in my chair. All right, anything else? What's that?
How would you know?
Good question. All right, we'll see you in whenever you're